everybody, we're here today and we want to talk about the new law in Tennessee that is just going across the internet like crazy and everybody's so nervous and scared and all of the different things. So just for some context, we are actually located here in Chattanooga, Tennessee. So we are in this market every day seeing deals getting done. Our company, ezREIclosings, we are the nation's largest transaction coordination company. So we help investors and wholesalers all across the country get their deals closed, get them over the finish line, and we make sure that they get paid. We have done this over 8,000 times in the last couple of years. I'm an investor. I've done over 1,600 wholesale deals since 2009. So we tell you all of that just so you understand we have lots of experience. Hannah is an investor and has probably closed, more deals on the TC side than anybody I know. So all of that being said, we are not attorneys. We are not licensed in this or any state. We did not sleep at a Holiday Inn last night, but we are pretty familiar with the law. Before we go into this, we did consult with a number of attorneys just to make sure that our understanding was clear. But again, this is just our opinion for our business and how we would help our clients. So all that being said, good news.
Wholesaling real property is now legal in the state of Tennessee.
Yay, cue the applause. Fantastic. So that's great, right? And this is good news. So, of course, the state of Tennessee, in order to regulate wholesaling, had to first admit that it's a thing. So this new law, it actually uses the words equitable interest, assignment, assignee, and wholesaler. So wholesaling is now a thing. So now that we've talked about all of that and that we are not attorneys, let's go through and read this bill. It is a very short bill. I will tell you it is 2 pages, very, very simple to understand, but we will read the important parts. I will also, below this, we're going to post a link to the law if you'd like to download it. Also, we're going to go through this. We're going to talk about the law, then we're going to break it down a little bit, and we will show you the additions that we are making to our contract so that we are making sure that we're complying with at least the minimum standards of this law. So let's get started. Let's Hannah, I'll let you read it.
Yes. So this is Senate Bill 909. This was passed March 25th of 2025. And the beginning of this bill just lays out the definition of equitable interest in wholesaling real property.
Yep.
So equitable interest, it's the right of a buyer to benefit or profit from real property after the buyer has entered into a contract for the purchase of the real property with the seller, but before the title has transferred.
Right. This is literally the definition of wholesaling, no matter where you're at, no matter what state you're in. Let's say in this law calls me the buyer, right? And that's based on the initial underlying contract. So I am the buyer with Mrs. Smith. I have her property under contract for $100,000. First step is I have a contract with the intention to buy. Second step is, maybe I will assign this contract. And this is what it's talking about, that portion when you decide to assign this to an end buyer. And lo and behold, the next section, 66-4-402, is called wholesaling real property. Wholesaling is now legal in the state of Tennessee, and this is telling you exactly how to do it. This is very simple, right? This is the teacher's addition to the book. So let's talk about that. What is this section about?
So it's telling you exactly what wholesaling is. Wholesaling is when a buyer or an investor enters into a contract with a seller to purchase the real property. After entering into that contract, then assigns their interest of the property to a subsequent purchaser for a higher price, therefore taking a profit.
Right. So it really is starting backwards. It's talking about your action or my action with that end buyer, the person who is getting assigned the contract. And really it just says that I have to let them know that I'm assigning my equitable interest in the property, which we've all been doing this for years and years and years. I don't think there's much of a secret that wholesalers are assigning their contract. So pretty straightforward. And I will show you exactly the updated language that is going to go into my personal contract and what we provide for our clients. So let's move on. Section 66-4-403, which says requirements for a buyer engaging in the wholesaling of real property. Again, this is breaking it down.
They're essentially saying, hey, now we're allowing wholesaling. However, we need to create some guidelines to make sure that this is being done correctly, because we know it's going to happen. It's always going to happen. It always will for the rest of time. So there are really 3 key points in regards to what they want to see when you're wholesaling, but they're broken up into 2 sections.
Yep. So the first section here says a buyer who has entered into a contract with a seller to purchase real property may engage in wholesaling the real property if the buyer discloses the following information: Wholesaling, perfectly legal. You just have to disclose, and it talks about 3 things. So let's talk about the very first one here.
So the very first one says that a potential subsequent purchaser or assignee, you must disclose to them the nature of you as the wholesaler's equitable interest in the property.
Simple, right? We've all been doing this for a million years. We're just going to clean up the language in the contract and make sure that we are 100% complying with what this new statute is asking for. Simple.
Now, it does not say that you have to disclose the details of the nature. You don't have to necessarily disclose to your end purchaser the price that you're under contract with the seller for or the nature of your relationship to the seller. They just need to know it's an assignment of your equitable interest.
Right. And
Something we should be doing.
Right. And that's one of the things that we've seen. Lots of videos popped up. This law is less than a month old, where people were panicking and their hair was on fire and they were talking about lots of things. You can disclose whatever you want. We are just talking about what the minimum standards for to comply with the law are. So let's go to number 2, or letter B, I guess it would be.
Yes.
It says the seller of the property. You must disclose to the seller of the property the buyer's intent to market this equitable interest prior to the execution of the contract and the effective date of any assignment of the buyer's interest to a subsequent purchaser of the real property at least 3 days prior to the effective date of the assignment, if the contract allows for assignments.
Yes. So 2 parts here. The first is that your seller needs to know you have an intent to market your equitable interest to an end buyer. A lot of contracts say in there already, when we were doing it in PL Investments as the buyer and or assigns, you're already disclosing that you may not be the subsequent purchaser.
Yep.
You're also usually have somewhere in your agreement that you have the right to market that property prior to owning it. That's a wonderful thing to have in there. So very straightforward. Nothing's really changing in that regard.
No, I think where people have gotten stuck here is in the language about 3 days prior to the effective date of any assignment. Now, there's a couple things here that could be a little bit confusing. The date that I sign or do the assignment contract with my buyer, to me, the way that we're reading it and advice from our attorneys is the effective date is the date of the actual closing. So this is saying that I would have to notify my seller 3 days in advance. However, we pose the question, why not just put it in our underlying contract? And then there does not need to be that additional step in there. So that is what we've done. I'll show you that at the end, that one very simple line that we are putting in our underlying contract that, at least in our attorney's opinion and in ours as long-term investors, satisfies that requirement. Should the law get updated down the road or there's a different ruling as case law comes out, that may change. But today that seems to, be enough. What else does it talk about?
So there's a couple of things that it talks about in regards to these disclosures to the sellers and buyers. The most important just being that they need to be in bold, large font print and included in the written agreement. Large font print doesn't mean it has to be larger than the rest of your contract.
But it can't be
smaller.
It cannot be the, number 2 font down at the bottom, right? Where it's hardly visible. And again, the spirit of the law here is that everything just needs to be disclosed to everybody. So that seems pretty straightforward. And then the last part here, it says an action for violation of this part must be completed within 2 years. So essentially there's from the time the law starts, any contract that was written after March 25th of 2025, they can look at it for 2 years. So in 2029, they can go back to anything written in 2027. Just to look back on these contracts. So we want to make sure that we are getting ahead of this and just adjusting the verbiage in all of our contracts. And again, like I said, at the bottom here, I'll give you a spot where you can actually get copies of the contracts that we're going to show you. And certainly we're going to show you the updates that we've done to our contract. Again, very straightforward stuff, nothing to be concerned about. We're going to add a couple of lines into our contract. And then the last part here, which is pretty important.
Yeah, this part only applies to transactions involving real property.
Yeah. So real property, obviously there's 2 types of property. There's personal property. Personal property is this microphone, my vest, my camera here. Real property is physical property. It's the land and the structures that are built on it. Cool. Good. All right. Let's move into the next part. Okay, great. Let's do a quick summary of the Tennessee wholesaling law. So number 1, let's start there.
Number 1, you must disclose to your buyer that they are purchasing it from an assigner, that you are assigning your interest to them. your
Right.
equitable interest.
Right. So very simple. We went over the law, and let's show you what this actually looks like in our contract, how we are going to make sure that we're covered here. Okay, so you'll see this is the contract that we use with our end buyers. It looks like a contract, but it's actually an assignment of contract. And again, if you comment below, I'll make sure that you get a copy of both of these. We provide this exclusively to our clients, but we will make sure that you get it. So here's what we have added. We've highlighted it just for the simple for you to read it, but it does have to be bolded. And this says, right, the buyer, this would be our assignee, understands that this may be an assignment of the seller, me, the seller's equitable interest in the property, and the purchase price listed includes the assignment fee. This contract will act as an assignment of contract if needed. So this line is actually doing a couple of other things beyond complying with this law. The reason I put this into my contract years ago is one, this was going to be our assignment contract, right? So it looks like a contract, right? But it's technically the assignment. So I want to just be clear there. One, the reason that we started using this, and we were the people that kind of pioneered this for the whole country 15 years ago, now everybody does it, is one, I didn't like the assignment contract where it says I'm buying for $50,000. I'm assigning to you for an additional $20,000, because now we get into an argument over what the assignment fee is. So we created this document so that it could be just one number. You're buying it for $70,000. First thing. Second thing, I added in this contract will act as an assignment of contract if needed, because that would satisfy hard money lenders who in their checklist said, I want to see an assignment contract. So third thing is we've bolded it and updated it to now comply with the law. And that says the buyer understands this may be an assignment of the seller's equitable interest. Those are the words from the new law in the property, and that the purchase price listed includes the assignment fee.
Beautiful. Very straightforward.
Right.
Number 2, the assigner must disclose to the seller their intention to assign that equitable interest to a subsequent purchaser.
Right. So first, what we were talking about here is our contract with our end buyer, but now we're going to go back to our underlying contract with our seller. You'll see that again, we use a very simple one-page contract. There's no hocus pocus. We want to make this as easy to understand as possible. And this line, also number 6, says this contract is contingent upon clear title and final inspection of the property by the buyer or the buyer's agent before closing, and that property is suitable for the buyer's plans and needs. This part is not specifically for this law, but it's pretty cool because now you don't need an inspection period. It just says that the contract's contingent basically up until the moment of closing. What we have added in and adjusted to comply with this law is buyer has the right to market their equitable interest, remember we're complying with the law, in this property or assign it to another entity effective at closing. It's bolded, it's large font, and we are doing exactly what the law says we have to do.
Yes, it's satisfying both of those points. So it's saying assigning it to another entity effective at closing. We're giving well more than 3 days notice here that there is a plan to assign it to a subsequent purchaser, and that is when it will go into effect.
Right.
So 2 birds, 1 stone.
Right. And you'll see this is not the only thing that's bolded in our contract. It has been like this for years and years. Purchase price, description of property, the agreement. We've added this section in, but seller warrants if they don't know of any county, city, county, or local government issues or liens. These are all very important parts of the contract. You do not need to leave it highlighted. That was just for us so that my old eyes can see it on the screen here. But that's really it, right? That satisfies all of the requirements of the law.
It does. And I think there's more to celebrate here than there is to be concerned about. We've got wholesaling real property being legal. They just want people to follow the basic rules that we're really already should be following in all of the other states we're working in as well.
Yep. So long video basically to say, add these couple of things into your contract and you should be good in Tennessee. If you have a contract in Tennessee, we want to help you close it. You can submit that contract at eztitleandescrow.com. We'll flash that up here on the screen. If you are doing deals and you want to grow your business, we would love to help you. We work with some of the largest and most successful investors across the country, making sure that their business runs like a top, that their deals are getting closed, and really that they're just removed from all the paperwork and added just aggravation of dealing with the transaction and collecting documents in different title companies. So we would love to help you at ezREIclosings. We are the nation's largest transaction coordination company. And again, we want to help you grow your business this year. And if this was helpful, make sure that you like and subscribe. We will see you on the next video. Anna, thanks so much.
Thanks.